One of the most common consequences of a domestic violence arrest is having a restraining order placed against the alleged aggressor. This happens very early on in the process. There are two main ways that the court system can stop you from contacting another person: the criminal protective order and the civil restraining order. If you are arrested for domestic violence, you will face one or even both of these orders. A criminal protective order is a formal court order entered by a criminal court judge. Its purpose is to protect the victim of an alleged crime from further contact with the defendant. Criminal protective orders accompany criminal charges. In a domestic violence case, the protected party is usually a spouse, child, family member, intimate partner, or household member. Now, typical protective orders include different levels of seriousness. There are full no contact orders, which are the most restrictive. There are residential stay away orders, which are middle level restrictions. And then there are no threatening or harassing orders, which are the least restrictive. The criminal protective order means that you can't have direct or indirect contact with the alleged victim. In addition, you cannot have someone else contact the protected party on your behalf. Only the judge can modify or remove a criminal protective order. Just because the protected party says it's okay to resume contact does not mean that you should do so. The protected party does not control whether the criminal protective order remains in effect. And if you violate the terms of the criminal protective order, you are subject to further arrest and prosecution for the additional crime of violation of a protective order. This crime is a Class D felony and exposes you up to 5 years in jail in addition to any previous criminal charges. Now, once a criminal protective order is entered by the court, it stays in effect until the end of the case or until it is formally modified by the judge. Criminal protective orders can restrict or entirely prohibit you from having contact depending on the restrictions imposed. Now, for example, if your client or you are a gun owner, you will need to surrender guns to the police. If you live with a victim, you will need to leave the home, and you could need to live somewhere else while the protective order remains in effect for months and months. These are some of the additional issues that come up with the criminal protective order: loss of gun privileges, the inability to live in your marital home, and they can disrupt your life immensely. Now, in addition, in domestic violence cases, the judge will set a number of release conditions on you if you're facing a criminal protective order. These conditions will be monitored by the court's family relations counselor. We have found that in domestic violence cases, the typical release conditions include group and individualized counseling and education, individualized substance abuse treatment and testing, criminal protective orders, and GPS monitoring. Now, if you believe that there's no valid reason for a criminal protective order, you need to make this challenge immediately, or else you waive the right to do so. Under our law, a person cannot make this argument later on in the case. It must be made during your first court date. Now, that's all the criminal side. Then there's the civil restraining order, which is a formal court entered by a civil court judge. Its purpose is to restrain you from having contact with a designated person or persons. Unlike a criminal protective order, which is imposed automatically by a criminal court judge in domestic violence cases, the party that wants a civil restraining order needs to submit the formal written request to a civil judge. This happens by filing mandatory forms with the civil clerk and can even happen before an arrest. No criminal charges are necessary to obtain a civil restraining order. The party that wants the civil restraining order must provide evidence, usually by a written statement, justifying the need for a civil restraining order. The party must show the civil court judge that they've been a victim of violence, or that they're in fear of imminent harm, or that they're being threatened. Now, civil restraining orders are limited to situations between family and our household members, or in situations where the moving party is the victim of sex assault, sex abuse, or stalking. Upon reviewing the moving party's application, the civil judge can do one of the following things. First, they can issue an immediate ex parte restraining order, which remains in effect for 2 weeks, followed by an actual contested hearing. Second, they cannot issue an immediate ex parte order, but schedule the matter for a contested hearing within 2 weeks. At those contested hearings, the civil judge can either dismiss the restraining order application or impose the civil restraining order for up to 1 year. After the year period expires, the moving party can request further extensions of the civil restraining order. Now, if a person violates the terms of a civil restraining order, they are then subject to arrest and prosecution for the crime of criminal violation of a restraining order. And this crime is a Class D felony and exposes you up to 5 years in jail. So take it seriously. If you know someone who needs this information, please share it with them. And if you have more questions, please contact us. We're here to help.